Hello and welcome to Topic 1, Lecture 1. And in this lecture, we're going to be learning about the Bill of Rights and doing a general overview of the court system. So what are we going to be covering in this lecture? Well, first we're going to look at the road to the Bill of Rights. And we're going to look at the role that the key founding documents play in the creation of the Bill of Rights. Next, we're going to talk about the Bill of Rights and the role that the Bill of Rights played in the ratification of the United States Constitution. And then we're going to end this first lecture, by taking a look at the organization and function of the American courts. So let's go ahead and get started. So as you know, this is a course on civil liberties. It's a course that's dedicated to learning about civil liberties within the United States. And as you also know, that these civil liberties, or these personal freedoms, that we find these personal freedoms outlined in the Bill of Rights. And so the first step that we're going to do in this class is to in order to have a fuller understanding of the Bill of Rights, that is the first 10 amendments to the United States Constitution, we have to have and learn about the relationship of the Bill of Rights to the other founding documents. Now, I'm sure that the vast majority of you in this class are aware of the key documents that are associated with the founding of the United States. But it doesn't help to do an overview of some of these key documents, particularly as we're thinking about the Bill of Rights in relationship to these key documents. Also, I'm sure that most of you are aware that before the United States became an independent nation in the late 18th century, that prior to that, starting at the beginning of the 17th century and the early 1600s, that the United States, before it became an independent nation, was of course colonies of England. And so from the early 1600s until the late part of the 1700s, in the 1760s and the 1770s, the colonies were a part of the British Empire. And so, as we also know, that as in the 1760s and the 1770s, following the French and Indian War, the American colonists decide that they no longer want to be a part of England, that they want to declare independence from England and create an independent nation. And that's the first key document that we're going to just touch upon and remind you of, the Declaration of Independence, that was written by the Second Continental Congress and signed in 1776. And as you know, the Declaration of Independence is a statement of the formal separation of the colonies from England, but it's more than that. That the Declaration of Independence is also a political manifesto that identifies the reasons for why we broke with England. And most importantly, and as it relates to the Bill of Rights, that the Declaration of Independence articulates key values of this new nation. So we're creating a new nation and we're identifying what our key values are. And so for those of you who have taken my American government class, you're very aware of that. Those key values that are outlined in the Declaration of Independence are that all men are created equal, all people are created equal, that they are endowed by their creator with these natural and alienable rights, and that this is going to be a form of government where the power comes from the people, not from the sovereigns, not from kings or queens, okay? And so it's important to know about the Declaration of Independence, or to refresh your memory on that, because the outline, those natural rights, those inalienable rights that all individuals have, that's basically, the foundation for what gets enumerated in the Bill of Rights. Your textbook also talks about another important key founding document, which is what's known as the Articles of Confederation. So that as we were formally breaking ties with Great Britain, that at the same time we needed to come up with a constitution, a blueprint for this new government that's being created. And that's what the Articles of Confederation is. It's the first constitution of the United States. It was written in 1777. It was ratified in 1781, and it stays in force until the ratification of the current United States Constitution. And as your textbook points out, that the Articles of Confederation, while it does create a constitution and a blueprint for the government of this new nation, it's really a reflection of what was already in place at that time. And so as it says there, that the Articles of Confederation basically centralized power in states. States were the ones that had the most power, and there was very limited power that was given to the national government. And so we did have a blueprint for government, but the blueprint for government for this new nation was that the states had most of the power and that the national government had very, very little power at all. Now, as you know, and as you've also were reading in your textbook for this week, that the Articles of Confederation was a good first step to creating a government for the United States. But there were a lot of problems with the Articles of Confederation. Because all the power was in the hands of the states, it was really difficult for a national government to get power and to take actual meaningful action internationally, and also take meaningful action to make sure that we had a unified economic system and really a unified, rule of law within the United States. And so, as your textbook talks about that there was a lot of concerns with the Articles of Confederation, and so there was a movement to change the Articles of Confederation, and that movement resulted in a constitutional convention that was held in Philadelphia in 1787 that basically created a whole new constitution. And so dissatisfaction with the articles leads to a constitutional convention in Philadelphia in 1787, and it's at that constitution that at that constitutional convention that a new constitution is created, the constitution that we have for today, which creates a blueprint for American government. And the Constitution that was created is not the same Constitution that we have today. It is in that the first 7 articles that were created at the Constitutional Convention is the basis for sort of the blueprint or the architecture of American democracy. However, as you also learned in your textbook, that in order to get that Constitution ratified, that there was a demand that a Bill of Rights be added to that Constitution. And so today the Constitution is 7 articles and 27 amendments, and those first 10 amendments is what makes up the Bill of Rights. And so you'll be reading in your textbook about the Bill of Rights, and in a second we're going to be talking about why there was no Bill of Rights that was initially added into the Constitution as a product of the Constitutional Convention in Philadelphia. And we're also going to be talking about why the states demanded a Bill of Rights in order to get the requisite numbers of states in order to ratify the Constitution. And so the Bill of Rights, as you know, is the first 10 amendments to the United States Constitution. We are going to be spending the entire semester talking about the Bill of Rights, and that the Bill of Rights is this listing or this enumeration of the freedoms that individuals have in the United States. So today we take the existence of the Bill of Rights as a given. You can't really even think about the Constitution without thinking about it, including the Bill of Rights. But as we were just talking about, and as you're reading your textbook, that this was not the case. This was not always the case. That in fact, the Constitution that was sent to the states for ratification, and we needed 9 of the 13 states to ratify the United States Constitution, it did not contain a Bill of Rights. So that constitutional document that came out of Philadelphia did not contain a Bill of Rights. But as you'll also be reading about in your textbook, it became clear that if the Constitution was going to be ratified, it needed to include a Bill of Rights, because states were basically saying, without a Bill of Rights, there's no way that we're going to ratify this. And to get the 9 states, an agreement was made between the so-called Federalists, who were saying, hey, you don't need a Bill of Rights. They ultimately saw the writing on the wall and said, okay, you ratify the Constitution, and our first act of our new Congress will be to propose amendments that would make up the Bill of Rights. And so, the Bill of Rights is a product of compromise, right? It's sort of like, wasn't in the first document, but then in order to get it ratified, there was an agreement that would be added. So let's take a look and review, why the Federalists, those who were at the Constitutional Convention, why they didn't think a Bill of Rights was necessary to be included in the Constitution. But then let's look at the argument from the state's perspective about why it was very important for a Bill of Rights to be included. So why didn't the framers include a Bill of Rights in the Constitution? Well, there are many reasons for why they didn't include a Bill of Rights. One reason was that framers at the Constitutional Convention said that the focus of the Constitution wasn't personal freedoms and liberties, but the focus of creating this Constitution was basically to create the infrastructure for American government. But that the focus of the Constitution was to basically create branches of government and then tell the branches of government what power they have. And that, if you get a chance, hopefully, to read the U.S. Constitution, that's what the U.S. Constitution does. Articles 1 through 3 create the Congress, the federal legislature, Article 1. Article 2 creates the presidency. Article 3, which will be of interest for our class, creates the federal courts, including the Supreme Court. And then the other articles deal with the relationships between the state and the federal government, federalism, talks about federal supremacy, and then talks about how we amend our Constitution and how we ratify our Constitution. So basically said that the point of the Constitution isn't personal freedoms. They also said that that Bill of Rights isn't needed. And the argument that they gave for why a Bill of Rights was not needed is because of their argument saying that the power of government is limited to the powers that are listed in the Constitution. And so when you look at the Constitution, Article 1 tells Congress what its powers are. Article 2 tells the president what the president's powers are, and et cetera. And so the idea is that government can't engage in a power that it has not been granted. And so you don't need a Bill of Rights telling government what it can't do. You don't need to tell Congress it can't abridge your speech or establish a religion, because it doesn't have that power to begin with. They also said that the Constitution actually does afford people some individual liberties in the body of the Constitution. And so, for example, in the Constitution, it prohibits these things called bills of attainder. A bill of attainder is where the legislature can declare somebody guilty without a trial. That's prohibited in the Constitution. Basically, you have a right to habeas corpus. That is, if you're charged with a crime, that you need to be told if you're arrested for a crime, you have to be told what crime you're being charged with, and other rights. And so they said there are actual rights that are in the Constitution. And then finally, they said that you don't need a Bill of Rights because not only is a cataloging of your rights unnecessary, because the national government doesn't have those powers anyways, but they said that it's actually dangerous to list or enumerate our rights. Because once you start writing down what your rights are, then you could assume that if it's not written down, you actually do not have those rights. So they said that there was some danger in including a Bill of Rights in the Constitution. So while the framers had good reasons for why they didn't include a Bill of Rights in the Constitution, the states didn't want to ratify the Constitution without a guarantee that a Bill of Rights would be added. Their reasoning was that, to begin with, the Constitution creates a lot of power for the federal government. Keep in mind that Articles of Confederation, the first Constitution, the federal government had very limited powers. For one, there was only one federal branch of government, the national legislature. There was no executive branch under the Articles of Confederation, and there was no federal judiciary. So this new Constitution really creates a lot of powers, and that the powers were quite extensive. And so that scared the states. They said, you know what, if we don't list what the freedoms of both the people and the states are, then it's likely that the federal government could very well abuse those powers if we don't tell them what they can't do. They also said, and this was this was Jefferson, Thomas Jefferson, he's the author of the Declaration of Independence, that Jefferson and others argued that there are certain rights that are just fundamental, inalienable. They're natural rights, that they come just by virtue of being a human. And that these certain rights are fundamental, they're inalienable, and that as such, they need to be formally recognized in our founding Constitution. And so to not add them into it would really be contrary to some of our fundamental principles. That is the principle of inalienable natural rights. There's historical precedent for a Bill of Rights. Your textbook references the Magna Carta. from 1215 that basically enumerates these inalienable rights. And the states also said, hey, look, state constitutions, so states have constitutions as well as the national government has a constitution. And so a Bill of Rights were included in state constitutions, and that didn't seem to be dangerous or problematic. Why not include it in the federal constitution as well? And the states won the argument, right? It was clear that the Constitution wasn't going to be ratified. So the first act of Congress was to empower James Madison with crafting a Bill of Rights that was then approved by Congress and then sent to the states for ratification. So all this talk about the Bill of Rights, and you might be asking yourself, hey, how well do I know the Bill of Rights? Well, by the end of the semester, you're going to know the Bill of Rights really well. But it's kind of fun to test yourself. It's sort of like you do a pre-test and a post-test at the end of the semester. So, here we have 10 amendments, first through 10th. And so there you have it. You're taking a look at them. Why don't you pause the video right now and get out a piece of paper and a pencil or a pen and just ask yourself, hey, what liberties are included in the first? What about the fifth? What about the ninth, my personal favorite amendment? What about the 10th? So take a moment to pause, and then we'll come back and we'll do a quick overview of what's contained in each of those amendments. So the First Amendment, we're going to be spending a lot of time talking about the First Amendment in this class. And the First Amendment includes 5 liberties. Religious liberties, which is the first, liberties relating to speech, press, assembly, the right to petition. Second Amendment, we're all familiar with the Second Amendment. Second Amendment has to do with the right to bear arms. The Third Amendment, not a real popular amendment, and actually, as you're going to find out, it's one of the a few amendments that hasn't been incorporated or applied to the states. It has to do with that the government can't quarter soldiers in your homes. The Fourth Amendment, one of the amendments having to do with the rights of those accused of crimes or suspected of engaging in crime. So Fourth Amendment has to do with how law enforcement and the government can search you and seize your property, usually needing probable cause. Fifth Amendment contains a lot of different liberties. It talks about that everybody has a the right to the due process of law, which we'll be talking about later in the semester. You can't be charged twice for the same crime, double jeopardy. You can't be forced to incriminate yourself. You can't be forced to testify against yourself in a court of law. And one of the first cases that we're going to be learning about is Barron versus Baltimore, and it has to do with eminent domain, the power that the government has to take your property for a good reason, but that they have to give you market value for the property that they take from you, or if they don't, they've violated the Fifth Amendment. Sixth Amendment, the rights of criminal trial. Seventh Amendment, the rights that if you're not a criminal trial, but a civil trial. The Eighth Amendment has to do with cruel and unusual punishment and excessive fines and bail. The Ninth Amendment, my favorite amendment, one of my favorite amendments, but I'm going to go out on the limb and say the Ninth Amendment. Remember on the last slide, we were talking about how one of the arguments that the framers made was that you don't want to enumerate your rights because there's a danger to that once you list them, it might be implied that if you didn't write the liberty down, the freedom down, that you don't have that freedom. Well, the Ninth Amendment basically it's the protection of rights that are not specifically enumerated in the Constitution. And so the Ninth Amendment basically says that just because we've listed these rights doesn't mean that these rights are not afforded to the states and the people. And then the 10th Amendment, which we will not really be learning about in this class, somewhat, but the 10th Amendment has to do with the powers that are reserved to the people and the states. So that's an amendment that deals with the rights of states and the power of the people that live in those states. So now we're going to turn our sights to take a look at the major institutions of American government, with a special focus, obviously, on the courts. So, as I referenced earlier in the lecture, that the Constitution, the first 3 articles of the Constitution establish the 3 branches of government. Article 1 establishes the federal legislature, and the federal legislature is composed of the House of Representatives and the Senate. So you can see that there. Let me put my magic pen on right there. This is the legislature. Article 2 establishes the executive branch, which includes the the establishment of the presidency and the vice presidency. And also the executive branch is empower, the Constitution tells us what the powers of the executive branch are, which leads to the federal bureaucracy as well, because they're there to help the president implement those powers. And then Article 3 establishes the federal courts. In particular, it establishes the Supreme Court of the United States. So we have Article 1, Article 2, Article 3. And the legislative branch makes decisions, it makes laws. The executive branch puts those decisions, takes those laws and enacts them, implements them, executes them. But what does the judiciary do? What is the function of the Supreme Court? Or even more broadly, what are the functions of courts in general? So what do courts do? What is their job? Well, probably the easiest way, and maybe the best way of thinking about what courts do, is the courts are there to settle disputes. They're an institution that when there's a controversy that arises, where there's disagreement about something, we turn to the courts to settle those disagreements, to settle disputes. So, one dispute that is settled in criminal courts and criminal law is that there's a dispute about whether or not a person is guilty of violating a law, right? That there's a law in the books and that it looks like there's probable cause to believe that a person engaged in this crime, but that we've got to prove beyond a reasonable doubt that that person is actually guilty as charged. And the settling of this dispute about whether or not this person is in fact guilty is one of the main functions of criminal courts. Another function of a court is to decide whether or not a person is responsible for some sort of harm or damage that they caused by their action. And this is often associated not with criminal law, but civil law. A lot of times we engage in irresponsible ways, or we don't follow through on a contract. So if you are a landlord and you rent to somebody, that's a contract. And if the person you're renting to doesn't pay their rent, then there's a dispute. The landlord says, hey, you owe me rent. And the renter says, yeah, I'm not going to pay my rent because you cut off my heat, or there are rats living in my house, or whatever. And you failed on your end of the contract. Well, you go to court, it settles the dispute. The court will decide who's responsible. Is the landlord the responsible party because they failed to get rid of the rats, or was the renter just lying and not paying its rent and saying that, hey, there were rats even if there weren't rats? So the court settles that dispute. There can be disputes over the meaning of law. A lot of the cases that you're going to be reading this semester have to do with how law is interpreted, like what's the meaning of the law. And when there's disputes over the meaning of a law, the courts will settle that dispute by helping to basically interpret the law, or give us the meaning of how that law should be interpreted. And a lot of what we're going to be doing this semester is asking the question about whether or not a law is constitutional. And that's a huge dispute and controversy to settle. Sometimes a law will be passed and implemented, but that people look at that law and say, wait a second, that law is fundamentally unconstitutional. It's unconstitutional because it's infringing upon my right to privacy, or it's unconstitutional because it's infringing upon my speech, or it's unconstitutional because it's infringing on my right to bear arms, etc. And so a big dispute that's settled, particularly by the Supreme Court, is settling dispute over is this law constitution? Are the actions of an executive, a police, or a prosecutor, are those constitutional? And so that's a major dispute that is settled. In particular, it's settled by the Supreme Court using the power of judicial review, which we'll talk about in a few weeks. Okay, so we're talking about what the main function of courts is, which is the main function is to settle disputes. But it's also important to just do a quick overview of the different types of courts that we have in the court system. And we'll also take a look at the organization that from the graph in your textbook that shows sort of the organization of the federal and state court system in the United States. So there are different types of courts that have different jurisdiction or authorities, the authority to hear cases. One of the types of courts is what's known as the trial court. And it's also a court that's known as the court of original jurisdiction. Original basically because it's the court that hears the case for the very first time. And so a trial court hears the case for the first time that you have trials that are both criminal trials and civil trials. And it's in this court where you actually have the presentation of evidence, testimony from witnesses. There could be a jury, and it renders a verdict, right, of either guilty or not guilty in the case of a criminal trial, or responsible or not responsible in the case of a civil trial. And so the trial court is the court that hears it for a case for the first time. And for the most part, in the textbook, you'll be learning about the Supreme Court. The Supreme Court only has the authority to exercise original jurisdiction in a very small few cases. Usually when it's a dispute between one state and another state, that's when the Supreme Court has original jurisdiction. But in many other instances, the Supreme Court is not a trial court, but it's an appellate court. And so appellate courts are the courts that, like the name suggests, that they hear the appeal of the trial court. And so when the trial court renders a verdict or a decision, some people may not like the decision, right? Might say, I was found guilty, but I'm not guilty. Or you could say, hey, the original court determined that this law was unconstitutional. Well, we don't think it's an unconstitutional law. And so the appellate court hears the appeals of the trial court. It has appellate jurisdiction. It can't hear cases for the first time. It can only hear them upon appeal. And basically what an appellate court does is that it's there to correct errors. It looks at what went on in the trial court, and it asks itself, the court asks whether or not there were in fact errors that went on in that original trial, and basically thus changing or vacating the decision of that lower level court, of the trial court. And so they correct errors, that there's not testimony that's given in an appellate court. There's not evidence that is presented, but instead both parties of the case will present briefs, written briefs to the court, and that the briefs justices, when doing an appellate review of a trial court, they'll read the briefs. There may be oral arguments that they listen to, and they may look at the court record. Okay, and so the appellate court, can either affirm the decision of the trial court. It can say there were errors in the trial court, so we're going to send that case back to the trial court for a retrial, or they can vacate or overturn the decision of the trial court. And then Supreme Courts are the highest court in the system, and they usually serve as an appellate function. Okay, so like I said, the Supreme Court of the United States is the court of last resort. They're the last review that takes place on court cases. And that basically the decision that they make is the final decision in that case. And we'll be learning more, obviously, about the Supreme Court as we go on through the course of the semester. So I want to draw your attention to the figure that's in the first chapter, figure 1-2, that basically shows you a diagram of the American court system. And so on the left-hand side here, I'll put on my magic pen. This is the federal court side. And on this side is the state court side. Now, there are 50 states, and each state has a different court system, a different court structure, but this is generally the way that it looks. And so I won't go over the chart. I'll leave it to you to read through it. But, you have the trial courts, you have the lower level appellate courts, and then you will have the Supreme Courts. And there are different names for each of the courts on the state side, but there are specific names for the federal side. And so I'll leave it to you to take a look at that table, that figure. Okay, so in conclusion, hopefully you found this lecture that refreshes your memory about the basics of the organization and institutions of American government. I really want to but there's going to be a quiz question on it for your lecture quiz. Watch the short box video, explainer video about the Supreme Court. It's a great video. You'll learn a lot. The process of how the court decides to hear a case is discussed in the topic 1 commentary, so make sure that you read that as well as the textbook. And feel free to come to office hours if you have questions about how the Supreme Court, the process of the Supreme Court's decision making in terms of how it decides to grant a writ of certiorari. The next lecture, we're going to be taking a look at legalism, the methods of constitutional interpretation. All right, thanks for listening, and I'll talk to you again soon.